Thank you, Your Honor. May it please the Court, my name is Katie Fiala and I represent the state in this appeal. We applied for further review after the Court of Appeals reversed the district court and remanded this case to the trial court for retrial without the breath test results. The Court of Appeals held the state must provide a private meeting room for a defendant and his attorney, which is not subject to audio or video recording, even in the absence of any request or indication that the defendant desires that privacy. Briefly, I want to lay out the facts of the case before this court today. This particular defendant was picked up for suspicion for operating while intoxicated. He was transported to the county jail for chemical testing. At the jail, the defendant was informed of his rights under 80420. A deputy here read the code section to him. The defendant then made 10 to 20 phone calls to various attorneys and family members. He was successful in getting a local attorney to come to the jail and meet with him. Now, this is the Hancock County Jail. It's a small jail, so in addition to the cells, there are a few small offices, a bathroom, a kitchen, an interview room, and the booking room. And the booking room is the room we're talking about here today. And the reason we're talking about the booking room is because this room is both audio and video recorded. So inside the room, there's a 12 to 14-inch speaker. This is where the audio was recorded. There's an on and off switch directly on that speaker. So anyone inside the booking room can turn off the audio recording. Defendant's attorney knew this. He was a local attorney. He had, in fact, turned off the speaker for other clients in other cases. The video camera cannot be turned off from inside the room. However, the video camera is visible in the room. It's not like this is a surreptitious recording. Neither the defendant nor his attorney made any attempt to cover that camera. Neither the defendant nor his attorney asked anyone from the state to assist them in covering that camera. And nothing from the meeting between the defendant and his attorney was used against him at trial. So the Court of Appeals found out under the facts that I have laid out that this was a violation of 80420. They determined the appropriate remedy was to suppress the results of the breath test, which showed the defendant exceeded the legal limit and then remanded for retrial. We now ask that you vacate the Court of Appeals opinion and affirm the district court. First, we assert that this defendant was given the opportunity to meet with his attorney without any sort of surveillance. So it is undisputed the audio could have been turned off inside the room. For the video camera could have easily been covered. This court noted as much in Walker, the 2011 decision. Neither defendant nor his attorney made any request for assistance in blocking the camera, and we now assert it's unfair to penalize the state because the defendant chose not to exercise his statutory right. Our second argument is that
the attorney have to ask for confidentiality? I mean, isn't it assumed that when they request an attorney, it would trigger the confidentiality? I mean, the attorney-client privilege and confidentiality is so ingrained in our society. Why would anybody assume it's not a request for a confidential meeting?
So my second argument is that there does need to be some sort of request for privacy beyond simply asking for an attorney. And I think...
But why? That's what I want to know.
Well, I think this case is an example. So this attorney knew he could ensure at least audio privacy. He chose not to. So for whatever reason, he did not think...
But isn't that a different issue? I mean, maybe you're entitled to confidentiality, but maybe it was waived because the attorney knew about the things in the room and waived it because he knew there was a speaker. I mean, if Sean knew he was a speaker and that everything's there, but I don't understand how, you know, give me your best argument that it's, when you ask to talk to an attorney, it's not to talk to them confidential, you know, in a confidential manner.
I look at the line of cases that this court has decided under 80420. So we have Walker, we have Garrity, we have Hicks, we have a number of other cases where a request is what triggers the statutory right. So here, it doesn't have to be a specific request, there's no magic words, but the defendant or his attorney needed to say something related to privacy. Can you leave us alone? Can we have a minute by ourselves?
Oh, but the point I think Justice Wiggins is driving on is when you go to the jailhouse and say you want to meet with your client, is it fair to assume that you're going to have a confidential meeting room? Because that's just part of the attorney-client relationship. I understand there's a camera. I'm not exactly sure where it is. It's mounted somewhere, apparently, a visible camera.
The record only shows it's visible.
Okay, all right, so we'll deal with that. And that there's a on and off switch. But can an attorney conclude that, well, my heavens, law enforcement officers aren't going to be monitoring my attorney-client meeting, which I've asked for, because of course it's going to be confidential. They're not going to be eavesdropping. They're not going to be behind the door. I wouldn't look behind the door to see, I mean, I take it. You wouldn't look behind the door to see if somebody's listening, because they wouldn't, I take it. And although there might have been a camera and a switch there, why couldn't they have assumed that it wouldn't be operable because they know you're using it for attorney-client?
So first off, I think this particular attorney did know. Due to his past experience, he knew about this on and off switch. I think in an analogous situation would be if the attorney did not close the door to the meeting room. So the state has given him the opportunity for a private meeting with his client. Attorney doesn't choose to close the door. That shouldn't be then held against the state to suppress the breath
But
result.
in your analysis, the state could put a bug in there and not tell anybody, listen to everything, but because the attorney didn't say, I want to do it in private, could be not subject to the state could use this stuff. I mean, there has to be something that attaches when a lawyer wants to talk to their client, more than just, I want to talk to him, and why don't you all guys come in and listen? I mean...
So my argument doesn't go that far. So here I think the important things are the camera was visible, the audio speaker was also visible. So
that may go to waiver, but how does it go to the argument that when a person asks to talk to an attorney, it has to be a confidential conversation?
Another approach here is this is a small jail. So this is the room we have available for meetings. So if there's going to be a private meeting, the way to make that meeting private is to cover the camera and to turn off the audio.
So is the statute different in small jails and big jails?
It's not, but I think the question is here is whose responsibility is it to turn off the audio and cover the camera? So here it was available to the defendant to do those things or to request they be done. He chose not to.
You agree it would be a different case if there were maybe some kind of deception or if the recording was concealed. The room appeared to be private and really wasn't.
I do think so. And under Walker, those communications, of course, couldn't be used anyway, but that would be
Let me
different.
raise another question for you. I mean, there could be situations where the attorney might want to be monitored. I've had that experience when, I visited certain clients. And in this case, this particular individual, the complaint had been from his ex-girlfriend that he was following her and had tried to run her off the road. And then apparently he had one of the deputies that stopped him was afraid his car was going to be hit. And so perhaps the attorney didn't particularly want to be not monitored.
What does the record show in terms of that?
So everything Justice Mansfield has said is in the record. There is also testimony during the motion to suppress from one of the deputies that this defendant had a kidnapping and some assault charges in the past. So there were factors that may have created risk.
Does the record show that the attorney wanted the video surveillance to continue?
There's nothing at all from the attorney in the record about that.
Well, wasn't it in the record the camera is visible and he didn't cover it up? Can't we infer from that he was okay with the camera being on?
That's certainly the state's argument.
See, how was the absence of a private room related to the ability of the state to acquire a breath sample? I mean, isn't that what the Court of Appeals suppressed the breath sample?
Yes, under Walker, the Court of Appeals said the remedy for this, the violation of 80420, was suppression of the breath test.
Why would that be the remedy?
Well, under past case law, since there does not have to be showing of prejudice, just the simple violation of the statute is what leads to this result.
Doesn't have to be any relationship between the evidence and the violation, or is it just one follows the other?
I believe the Court of Appeals determined one follows the other. And another problem here is this sets up an opportunity for defense counsel to manufacture a defense for a client, even in the absence of any prejudice, which is exactly what we have in this particular case. I guess another way to present the question before this court today is how does the defendant invoke the right to this meeting with his attorney? And we argue the answer is a simple one. He must ask for it. So in some way, the defendant or his counsel must do something to indicate privacy is what we're looking for. And there I rely on...
I'm sorry, I'm going to go back.
Yes, Your Honor.
I'm going to interrupt again. I want to follow up on what the Chief's question was. So I'm wondering whether the appropriate remedy here? What if we do find, yes, there's a violation and we ought to have this, the attorney and the client ought to expect to have this confidentiality without the necessity of specifically requesting it, but yeah, what is this really the appropriate remedy under those circumstances? I know we've done that in other contexts, but to me there seems to be a real disconnect between having, you know, now they find out after the fact that, oh, it was recorded, but did it have any bearing whatsoever on the attorney's advice to his client to go ahead and take the breath test that would require them to be suppressed?
I don't think there was any bearing on what this particular attorney told his client. So this attorney was not the trial attorney. Defendant has new counsel by the time this issue is raised. And there's simply nothing in this case that shows prejudice. And again, that's illustrated by the fact that the audio wasn't even turned off. So this attorney clearly did not care that his communication could have been monitored. There's no evidence in the record. It's a little unclear, but I don't even believe a deputy was listening to this particular conversation, but it was recorded nonetheless. But again, there's no prejudice here. So
That caused us to overrule some of our cases, though. I mean, we've held that to be the remedy and walked, you know, as recently as a few years ago.
That's certainly true.
We have to overrule Walker and I can't pronounce it, or Hellstern.
I think this would give the court an opportunity to look at those cases again.
And they're about a year or two old, aren't they?
Hellstern is 2014, Walker is 2011. And due to the prejudice issue, which I think is illustrated by this particular set of facts.
Did the attorney know the cameras were running? One of the reasons I'm asking, I mean, we have cameras in this courtroom, and they're probably running now. I assume they are. But on the other hand, if outside of our court session, and there was some attorney-client conference going on, the cameras would not be operable. So I understand that there's visible cameras, and I understand that there was the switch, but could an attorney have assumed, well, I'm using it for attorney-client privilege, they're not going to be listening to me, they wouldn't do that? Or does the record show, again, that he affirmatively knew that the system was operating?
So there's nothing that clear in the record. What we do have is this is a local attorney who does a lot of work at this jail in this particular courthouse. So as part of other cases, I think you could take judicial notice that he would have gotten copies of meetings in the booking room, the interview room, for other criminal defendants that he has represented. But there's nothing in the record about this case. Yes, Your Honor, that comes from the motion to suppress hearing. One of the deputies testifies about his personal experiences with Attorney Hova, who is the first attorney in this case. Again, we would like to emphasize the risk of manufacturing a defense, which I think is shown here, and this is the issue we've been talking about mixed in with the lack of prejudice shown in this particular case. So for all of these reasons, we ask you to vacate the Court of Appeals, affirm the district court, and affirm the defendant's conviction. Thank you.
Thank you as well, counsel. Mr. Kuehner.
Thank you. Chief Justice, Associate Justice, Counsel. My name is David Kuehner. I'm with the Eggert, Erb, Mulcahy, and Kuehner law firm out of Charles City, Iowa, and I'm here to represent Mr. Randall Lamoreux. Once again, this court has presented a question under 80420. This is the second time in the past few years that this issue has come before the court. And one of the things is that the legislature in this case, or in this statute, made it clear what their opinion was about the privacy and the ability of someone who's been arrested, only arrested or placed under custody under in this situation, an operating while intoxicated charge, their ability to consult with family members, with attorneys, and to meet privately with an attorney at the jail or other place of custody.
But counsel, I'm really interested in this, the last argument made by the state, which has to do with the prospect of the rule that you're advocating, creating a circumstance in which defense counsel could manufacture error by intentionally failing to either shut off the audio or cover the camera and prevent the video. That's really troubling me, and so if you could address that, I would appreciate it.
Well, I think one of the things this court has the opportunity to today is to have clarity in the situation and provide a way for us to predict what the future behaviors at our jails across Iowa should be. The statute says that attorneys shall be permitted to see and consult confidentially alone and in private at the jail. I think a bright line rule saying no recordings of any kind are allowed. And I think that way, if you go under the blanket rule saying that you cannot record it unless there is a safety issue, which I assume you would need to disclose beforehand, then you won't have to worry on the experience of the specific attorney as to whether or not there is some issues.
But Mr. Kuehner, you've quoted the statute accurately. It says, and I agree with your quotation, an attorney shall be permitted to see and consult confidentially, et cetera, shall be permitted. One seems to me reasonable interpretation of that is that the attorney has to ask for it. In Walker, the attorney asked for it and didn't get it. Here, the attorney didn't ask for it and didn't get it. So maybe it's a different case, right?
Well, what I think is that it's not up to the attorney to be able to ask to see a client. It is up to a client to be able to see an attorney. So I think it should be...
An attorney shall be permitted.
Right, but if I go up to a jail when there's been an arrest made, I'm not going to be able to see someone unless that client is the one who's asking to see me, unless I have a pre-existing relationship with that client. So I think the focus here needs to be on what the defendant wants, what the defendant, or, you know.
Well, but the facts of this case are frankly somewhat unusual, I think. I might buy the argument that says you can ordinarily assume that you get a confidential setting. That you don't have to ask for it. You say, you show up at the jailhouse and say, I want to meet with my client, and they say, okay, there's the room. You don't say, is there eavesdropping there? Is it going to be private? But here it's a little bit different because here you've got a camera apparently visible, and the record shows that the lawyer knows there's an audio switch, and yet does nothing. And what Justice Hecht is suggesting is that maybe, if I may, maybe the lawyer says, look at this. It's on. I'll just proceed with my interview, and we'll see how things work out. And if it doesn't work out favorably with my client, I'll say, well, see, it wasn't confidential.
One of the ways to prevent that is to require jails not to do any type of recording at all. Then the only time when that would happen is because a jail failed to follow what's required by statute.
In Iowa, every jail's different, and every jail has different facilities. Tell me your best argument. If I buy your argument, it has to be confidential. Tell me your best argument that it wasn't waived. Because if we adopt the is confidential waiver theory, you can't manufacture the defense if you waive it. So tell me why this lawyer didn't waive it, knowing he shut it off before, knowing the camera was there, and knowing the setting.
Well, I think it's important, again, to look at the defendant. Did the defendant know about the recording? He is the one who can waive the privilege, not the attorney. The attorney-client privilege, as understood through the Sixth Amendment, is something that belongs to the client. If an attorney...
But you're making a statutory claim, I think, and as an attorney shall be permitted.
Well, but I think that is, the statute, is also subject to the Sixth Amendment reasonable expectation between attorney and client.
But that's not raised in this case. The statute's raised in this case.
Right.
And the statute says the attorney may be permitted confidential. And I'm going to assume that means the attorney should understand and people providing the room should give them a confidential room. But why didn't this attorney waive that by knowing what's in the room? And if he did, how can he come back and say, claim foul?
And in this specific case, I think the record is clear that had the attorney wanted that confidential room, it was not available to him at all anywhere in the jail facility.
Let me ask this hypothetical. Supposing I walk into the jail, to the room for conference, and there's a deputy standing in the corner, and he's smiling.
Right.
And this is my confidential room. And then I smile back, and proceed with the interview. Would I have a claim then?
Well, I don't think you would, and in that case, the presence of the deputy would be both obvious to the attorney and to the client. Whereas a client may not be, and especially when you're dealing with a client who might be intoxicated, they may not be aware of what all's going on in the room or what that camera is up in the corner if it's not readily labeled as a camera and that recording may be going on.
Well, the record, apparently the record shows that it was visible. And where was the switch, and maybe the state will help us, but where was the switch for the audio?
I am not sure where the switch was for the audio. But I think one of the other things is as far as...
Isn't this distinguishable from the case where the state or the county would hide a microphone in the room and you wouldn't know it's there? I mean, it's a little different situation than where everything's in the open and the attorney and maybe even the client knew what's going on.
Well, I think when you hide a microphone, then you get into other situations that are not covered under this statute. And I think that's, illegal recording of private conversations, which may run afoul of other statutes. I think for this one, because no private room was available, I think, it is a violation of this statute as written by the legislature.
Well, that's not really true, because a private room, they have a private room if once they cover the camera and turn off the sound, right? Why is that not with the camera off and the audio off, why isn't that a satisfactory private room for 80420?
Well, I don't know in this situation if the camera was able to be covered. I cannot remember that, if that was in the record or not. But I know from my personal experience in other jails where I go to, that is how they have remedied the situation. But the covering, in the jails I go to, the covering is there. It's pointed out to attorneys, and they know that it's very obvious that they can have that privacy if they so choose. Here, I don't think there was anything obvious to have that privacy.
But if the attorney knows that he has the right, again, based upon our previous case law here, that he has a right to a private and confidential communication with his client, if I'm walking into that room with my client and I see a camera and sounds like a speaker or something that you can turn on and off, and if I've read Walker, I'm going to say, well, I'm not comfortable with this. Do you have another room? Or can you provide me with another room, because I don't think this meets the requirements of it. But then to come back now, later on, and say that, it seems a little disingenuous to me.
Well, I think one of the issues with that is not all attorneys practice in criminal law. I mean, there could be a situation where somebody has a nice office practice where they don't do any courtroom work anymore, and they may have a client whose son or daughter was arrested and they agreed to go down. That attorney would not be aware.
That's not this fellow. This fellow had apparently been in that booking room a lot before, right?
That is correct. But
I mean, normally in our system, there a lot of things the attorney has to ask for. Not everything is self-enforcing automatically, right?
Right. And in this situation, the defendant asked to see the attorney. So what that would be then is you ask to see the attorney, and then you also ask to see the attorney privately. And I don't know why you should have to make those two different requests when it should just be one request to meet with your attorney, and that should automatically be private. Okay.
I'm sorry, I'm gesturing. I'll tell you I'm being repetitive here probably, but I may be with you on the notion you don't have to affirmatively ask for confidentiality. Ordinarily, perhaps, you could assume when you go to the jailhouse and ask law enforcement to meet with your client, you can assume, because of part of our culture, that it's going to be private. But then you walk in the room and you see a camera sitting there and a box of some kind, particularly when you know that that's there and you know that these are capable of recording. It kind of puts you on inquiry notice of some kind. This doesn't look quite right. And in order to avoid Justice Heck's little concern of saying, oh, this doesn't look quite right, I got it, the rule in this narrow fact situation that we're presented with might well rather be you don't win. To avoid escaping to avoid Houdini, but at the same token, defending the notion ordinarily you go into a room and you can expect confidentiality, but not here when you're on notice of what's going on.
Well, I think what we have here is we have early stage restriction of someone's liberty by the arrest. And during that time of arrest, there's no court involvement. There's no magistrate to run to because it hasn't got to that process.
When it's run to the magistrate, you just say, Jake, what's going on here?
But within the 2-hour limitation for doing the chemical test, I think that is not practical, especially in the middle of the night. I don't know if a lot of magistrates would want to answer the phone to talk to their defense
Jake
attorney.
wasn't a magistrate. Jake was my deputy. I'm sorry. The people in the area, I mean, you know, I just say, hey, you know, is this thing on?
Well, but I think when the state is restricting liberty at this early stage, I think it's important upon them to provide any relief possible for someone to have what few rights someone in custody has at that time.
But are lawyers that stupid that when they see a speaker, especially when you shut it off, or microphone, not a speaker, especially when you shut it off before in his camera, that, you know, he should figure out, I need to make sure this room is private. And if he doesn't, I mean, I think, why should we give the defendant a free defense? Because then you're allowing a manufacturing of a defense. Now, if the lawyer didn't know about it, I might be more sympathetic to you, but it seems to me you can't play games. Trials aren't games. I mean, they're seeking the truth, and games shouldn't get in the way of seeking the truth.
Unfortunately, I may, you know, some attorneys may actually be that stupid. I mean, using your word there. It's a possibility that they don't know to ask to have the camera turned off. And I think when you have a jail system with you know, a very limited number of jails versus how many attorneys could possibly be in the situation, I think from a public policy standpoint, it's much easier to regulate the jail in this time than to ensure that all the attorneys are familiar with what the law is and what rights their client would have.
Mr. Kuehner, the last sentence of the statute declares that a violation of this section shall constitute a simple misdemeanor.
Yes.
So it's a crime that we're talking about here. Why is the remedy that is imposed a suppression of a breath test that occurred sometime after this with no hint that the breath test was acquired because of whatever the cameras that were in the room?
Well, the remedy was set up forth by this court in Walker, and they just wanted to have a situation where a defendant whose rights have been violated, rights that have been clearly stated forth by the legislature, it shouldn't be up to the defendant to show the prejudice. So it's, the court came up with the per se rule that a violation is prejudicial. And I think that is a bright line test that was created by this court, and that's what we're asking for here today, is to extend the bright line rule so that further violations are not occurring in the future, especially over something as easily to control as jail.
Right, so if this was a different crime, let's say it was a murder, and this occurred, and then 2 days later the state uncovered the incriminating evidence, and would they be prohibited then from introducing that at trial?
Through inevitable discovery, I think they would be able to bring that up at trial.
Well, what if there was no inevitable discovery? So you're saying that there doesn't need to be a relationship between the violation of the statute and however the evidence would be acquired in the future?
I think when we're trying to protect the rights of someone, I think the rule for the exclusion of that is the correct rule. And just because the exclusion of, I mean, there was evidence to bring them to the jail in the first place.
Would the expression by the legislature that we're talking about conduct that amounts to a crime indicate that there has to be some sort of intent by the peace officer or other people violating this statute?
I don't think there's anything in there saying that there's an intent requirement, because I think this imposes a duty upon the officers, and it's their failure to act that causes the crime, potentially.
Thank you.
Thank you.
Ms. Fiala, a rebuttal?
I have a couple of clarifications to make. So we would agree with Justice Waterman that this particular room could be made confidential simply by blocking the camera, turning off the audio. So that was available in this case. I would also like to just point out part of the conclusion in Walker. So this court says, quote, "Those holding custody of arrested persons should honor attorney requests for a private, barrier-free meeting," end quote. This court goes on to say that upon request, recording devices should be turned off. So that's what we're looking at in this case. It's undisputed. There was no request related to the recording devices in this particular case. And I want to go back to my two arguments here. The first argument was that this defendant did have the opportunity to meet without recording, and I think some of the justices have called that a waiver argument. And my point here is that the defendant's choice not to exercise the right shouldn't be held against the state. Secondly, we do think there was no invocation of the statutory right here. There was nothing said related to a private meeting. And under the case law, I think there does need to be a request made. Onto this idea of prejudice, and I think there should be a relationship between the violation and the remedy, because the point here is not to trap the state and suppress this breath test result. So we're going back for a drunk driving trial without a breath test, which of course is a valuable piece of evidence. And this case just illustrates the reason where there should be prejudice. Even if prejudice is presumed, the state should have the opportunity to show there was no prejudice.
But isn't it, we talked about these other cases, the considerations are you can't have a candid conversation with your clients. You can't see whether or not you should tell them to take the test or not to take the test. And I think it's just different than a murder case or any other case. But because you're giving advice whether to take the test, we have a hardline rule, and it's been in effect for a long time. And we reaffirmed it in the Walker case, as you said, that you can't get the breath test. Now, would it apply to murders? I don't know. Would it apply to other crimes? I don't know. But this is a situation where it's important that there's absolutely candor between the attorney and the defendant whether to take the test. So isn't this a little different than those other situations? Or was Walker decided wrong?
So I think this particular statute certainly comes up most of the time when we're talking about the breath test, when we're talking about drunk driving. I think Walker could be revisited for these prejudice issues we're talking about. But on the other hand, not all attorneys want to perform their own sobriety testing of their clients. There's no indication here. In Walker, that attorney had specific things he wanted to do. The glare on the glass prevented the nystagmus test. He couldn't smell the breath. Those obviously weren't problems here. We're not talking about a barrier. But that attorney could specifically show how his advice was not as effective as it could have been had he been allowed to exercise the client's rights under 80420. And we would say just the facts here are simply different than the situation presented to the court in Walker. So for all of these reasons, we ask you to vacate the Court of Appeals, affirm the district court, and affirm the defendant's conviction. Thank you.
Ms. Fiala, thank you as well. State versus Lamoreux is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.